Welcome back. So this is another video in the series that looks at the jury in the United States, or the American jury. In the previous video, we looked at the constitutional provisions for a jury trial. In this video, we're going to look at the actual jury statute in Illinois, right? So I have actually read all of this, and what I've done is that I've tried to break it down to the most important parts, or the most pertinent parts as I saw it, right? Because I don't want to put you to sleep. I want to avoid you falling asleep in this video. So I'm just going to try to condense this information so that you can get it in its purest form, right? So basically, if you want to read this statute as I have, you can just do a search on Google for 705 ILCS 305/Jury Act, or you can just go to the Illinois Government Statute website and you can just look up the Jury Act. But Google should get you there. Now, again, we're looking at Illinois, but this video really is going to apply to all states, generally speaking, right? Now, each state is going to have its own specific twist, and it's going to have its own little, nitty gritty details. But on a high level, all statutes for all states are based off of the federal statute, right? So the essence of the federal statute is going to apply to all states, right? So right now I'm not reading any federal statutes. I'm reading in Illinois, but the things that I'm reading are general, high level stuff. It's general and it's high level, so it's basically going to apply just about any state you go to. Now, of course, I'm not a lawyer. I didn't go to law school, so take it with a grain of salt. I'm just rereading information to you. And of course, you don't want to go to court in Baltimore and say, well, the Illinois statute says this. You want to actually read the Baltimore statute as it pertains to the jury, right? But all things considered, they're generally on a high level going to be the same. So let's get into it, right? So what I've done is I've read this thing, and on the side, I've basically come up with questions. And these questions and the manner in which we're going to answer these questions is designed to not put you to sleep. Hopefully, if you fall asleep, let me know. When you wake up, leave your questions, comments below, and say, hey man, this video was boring. I don't know why you keep reading this stuff on the internet. You need to stop. Let me know. Let me know if you want me to stop this. Anyway, the first question is, how did they come up with the jury, right? Well, basically, they're taking identification cards, they're taking disability identification cards, they're taking driver's license, they're taking people who've made unemployment insurance claims. And actually, those are the people who they should just take everybody from unemployment, because basically you're not doing anything. They're just sitting around doing nothing. So those people can just go and be on the jury. And actually, I wonder, just going off on a tangent, maybe it should just be the duty of an unemployed person to go to jury trials, right? Let me know what you think about that. Should unemployed and disability and people who are disabled, right? Like, let's say you got a funny walk, right? And not being disrespectful to people who are disabled. But let's say you have a disability of the body, which means you can't move around, but your mind is intact. So should you be responsible for permanent jury duty? And should unemployment people be responsible for jury duty for the period that they're unemployed, because they're not doing anything, right? Let me know. It's a crazy idea. I just thought of it right now. So leave your comments below. Let me know what you think. Right. So basically, if you've applied for any type of service, driver's license, uh, a identification card, so on and so forth, unemployment insurance, basically you're giving a government information about you, where you live, so on and so forth, so they have the update information, or at least it was update at the time that you gave it to them, and that's what they use to build a initial jury list. Next question: what are the requirements for being a juror? So basically, you have to be 18 years of age. You have to live in the county where the case is being held. And number three is just really funny and is actually tricky because they're basically saying you have to be a fair character, right? And you have to have approved integrity. You have to have sound judgment. You have to be well informed. And you have to be able to understand the English language. It's okay if your disability keeps you from talking, but you have to be able to understand it, right? So sign language is acceptable, right? So, and you also have to be a citizen of the United States of America, and except otherwise specifically provided by the statute, no person who is qualified and able to serve as a juror may be excluded from the jury service in any court of the state or on the basis of race, color. So basically, they can't discriminate against you because you're disabled, you're black, white, fat, Chinese, or whatever. So basically that's how they determine those are the requirements for actually being on the jury, right? So they pull up this list, and then after that, the people on this list have to meet this criteria. So just going back to number three is kind of tricky because who's to say you're not of fair character, right? How do they determine that? Maybe that's a really good spin-off video series, right? How do they determine whether or not a person is a fair character? How do they determine a person is approved integrity, right? How do they prove, basically, I take that to mean that you have integrity. How do they prove that a person has integrity? How do they prove that a person has sound judgment, right? How do they prove that a person is well informed, right? Because you could be the type of person that's not paying attention to anything that's going on in the world. You just, you're wealthy, or you, for whatever reason, you don't have to worry about a job, and you just sit in your mom's basement all day, eating Doritos and playing video games, and you don't care about the news. You don't care about going outside, and you're just happy in your own little space. Then would that disqualify you? Would you not be well informed, right? So some of this stuff is a little questionable, and it probably makes for a good video series on how they can determine this stuff. Let me know if this is something you're interested in. Questions, comments below. A donation basically would help if you're seriously interested in this type of material. Moving on, and I didn't put a question here, but I think the question should have been jury notice, right? How do they, oh, this is notice to the employer. And basically, what this section says is that your employer cannot punish you for serving on the jury, right? So you can't be fired or discharged, or you can't be threatened to be fired if you decide to serve on the jury. And it basically says that you have to give a reasonable notice, right? And as long as you give a reasonable notice, then you should be protected, right? And reasonable notice is basically, in this case, is letting them know a day or a day after that you receive notice that you have to serve on the jury, right? And it also has some provisions about suing your employer if he tried to punish you. And I'm not going to look for it, but there's another part in this where it says basically that if you work night shift and you're on the jury on the day shift, well, you're excluded from work that evening because you have to focus on being on the jury, or you've already done your time, right? To you've done a civic duty in the sense that you went to the jury in the day. You should be excluded from working at night, right? So that's that. Moving right along. Another question: how do they select jurors from the list, right? So they have this list, and basically they need to whittle the list down. How do they do that? How do they reduce the number of people on this list and figure out who they're actually going to get to come in, right? And I'm just going to give you a hint. They basically draw names from the bag, right? That's the gist of it. So I really don't need to read all this to you, but basically they get together at least 20 days before the actual trial, and then they draw out all the names, and basically from there they basically reach out to people and notify them, right? Which we're going to talk about later. And they actually put it, it looks like they can actually just take names and put them in a bag. And then what happens is that the clerk of such court shall repair to the office the county clerk, and in presence of a judge of such county clerk, after the box containing names has been well shaken, right? So they literally have a box where they're shaking up. They put all these names in, they shake it, and then the clerk is blind. This sounds like some type of an occult ritual, right? The clerk is blindfolded and shall without partiality draw from the box, right? So this was all before the age of computers, right? Because now you have computers and you can easily put all those names in a computer program and tell that computer to randomly pick several, the amount of jurors that you need, right? So basically, that's actually covered in section B, and basically the computer. I like to have that job. I like to be the guy whose only task it is just to press the button on that computer program to pick the jurors. And I bet you that guy is probably making like $200,000 a year just by doing this, right? Because he's going to come in and say, hey, I'm a computer programmer. And if this program stops working, or if you have some type of networking issues, you need someone with my expertise to come in. As a matter of fact, I don't want 200, I want $300,000 a year. I guarantee you that's what's happening. So basically, they're either using a computer programmer to whittle down the list, or they're putting names in a box, right? And they're selecting the names with a blind. They put a blindfold on, and they put their hand in the box, and then they pull a name one at a time. Now, what I actually didn't cover, or I didn't mention as of yet, is that they're actually building several lists, and one list is going to sort of be the main list, and then they're going to build alternate lists for in case somebody doesn't show up. So just moving right along, trying to get to this without putting you to sleep. What is the next question here? The next question: how are people notified of jury duty? That's easy. They basically send you mail, right? You get a notice in the mail. Let's see here. Let's see if I can actually find it. Yeah. Issue summons of sufficient number of petite jurors, not less than 30 of persons such drawn, given their residence, and commanding them. Oh, so you're commanded to show up. To appear at the place of the holding of such court, directed, and a like number to appear in the same hour. Okay, so the issuing clerk may use first class mail as the initial forms of summons, incorporating any reasonable form of request for acknowledgement, which is deemed practical and which would provide a reliable proof of service, right? So first class mail, right? And I forget what first class mail is, but I think if I send you a first class mail and you live in the same state, you should get it within 1 to 3 business days. Anyway, moving on. The next question is: what if you're unable to be a juror because of personal issues? Well, they have provisions for that, right? So basically, if the duty is going to cause a hardship, then you can be excluded, right? I'm just going to sum it up with that, right? Because it goes into details on what type of hardship, but honestly, a hardship is a hardship, right? So I'll read some of the details. So such service would impose an undue hardship on account of nature of the prospective juror's occupation, business affairs, physical health, family situation, active duty in Illinois Guard or Illinois Naval Militia, or other personal affairs, and calls for his or name to be returned to the jury list or general jury list, right? And basically, it goes on to talk about family hardship. But this is the gist of it. If you have some type of legitimate reasons on why you don't want to be a juror, then you simply just provide it, and then you don't have to do it, right? And by legitimate reasons, I mean it's you're going to be hurt in some way by actually being a juror, right? I mean, it could be, and I'm going to go out on a limb because I haven't researched this, but let's say you're making X amount of dollars, and if you miss that one day, it's going to cause you not to be able to pay your rent that month. Then that's a reason for not being a juror, right? Because some of these trials they can go for weeks, right? So and the money that you're going to get potentially get from work basically is going to cover your rent. If you don't get that money, then you're not going to be able to pay rent. They would either have to maybe reimburse you. I would imagine. I actually didn't see anything in here about payment for being a juror, so I don't know that you get paid. So, but if rent could be one potential hardship, you can't afford to miss work or something like that. Moving right along. Next question. Okay, what if the potential juror has heard about this case in social media? Can they be excluded? And this is a really good question, right? Because now we live in a time where everybody's connected. Something happens in Russia, you can probably hear about it here in Chicago, right? If you're on that same channel, like that mental wavelength, on that mental frequency, you can hear about it here in Chicago, right? So something happens in California and it's bad enough, you can hear about it here, right? So should you be excluded from being a juror, or should you be prohibited, which is a better word? Should you be prohibited from being a juror because you heard about this case in social media, right? Let's find out the answer. And this one I'm going to read. It shall not be cause of challenge that a juror has read in the newspaper an account of the commission of a crime with which a prisoner is charged. If such jury shall state on oath that he believes he can render an impartial verdict according to the law and the evidence, the trial of any criminal cause, the fact that a person called as a juror has formed an opinion or impression based upon rumor, upon a newspaper statement, about the truth of which he has expressed no opinion, shall not disqualify him to serve as a juror in this case. If he shall upon oath state that he believes he can fairly and impartially render a verdict therein in accordance with the law and evidence, and the court shall be satisfied with the truth of such statement. Wow, that is incredible. That's a lot to take in right there, right? Because basically, and I'm going to read this again just to make sure that I understand it right. In the trial of any criminal cause, the fact that a person called as a juror has formed an opinion or impression. Wow. So you could now first, I'm just going to say this. It says newspaper, but you have to understand this is an old act. It probably should be updated. It says newspaper. Let's be real. The newspaper was social media in the 80s. It was social media in the 70s, right? So the fact that you heard about this case on Twitter, on the news, on TV, or on Facebook, the fact that you heard about it doesn't bar you from being a juror. As a matter of fact, the fact that you have already formed an opinion or an impression about the person and their guilt in the matter doesn't bar you from being a juror. And this is just simply crazy to me because I've always thought that if you knew about the case before actually being called to be a juror, that you should be excluded because you would be biased. But according to this act, that's not the case. So that's pretty interesting in and of itself. And maybe that's a really good spin-off video series. If you want that series, definitely drop a donation and I'll go and make it. But for the most part, to me, I think this is fascinating because basically it's allowing for a person who's already biased to come in and basically act as a jury so long as they can. Well, I guess it doesn't say bias, so I shouldn't go that far, But if you've already formed an opinion, wouldn't you be biased? I don't know. To me, leave your questions, comments below, and answer this question. If you've already formed an opinion, does that make you biased? Right? I can't really think through this right now because I really just want to get through this video. But please sound out below. Does a formed opinion make a person biased? So, but at any rate, it allows for a person who's already formed an opinion to come and be a juror, so long as they can state under oath that they're going to essentially do the right thing, which is basically render a fair and impartial judgment based on the law and the evidence, right? So that this is crazy to me. This is crazy because I can already think of some cases where people are going to basically scream bloody murder if a person comes in with a formed opinion, right? And I'm not going to get into those cases now, but yeah, that is just absolutely crazy to me. Leave your questions, comments below. Let me know what you think about it. And also, I want to know if a person has formed an opinion, does that make them biased, right? So, moving along, what if I don't care about being a juror and choose to say, screw it, I'm not going. I don't care, and I'm not going. Well, basically, it looks like they fine you anywhere from $5 to $100, and you're going to basically be guilty of contempt of court. And basically, a contempt of court is not a serious charge. It's serious. It's serious in the sense that you're thumbing your nose, you're flicking your finger up against the law, and you're not doing your part in society. It's serious in that aspect, but it's not going to go on your criminal record, and people could probably still find this information out if they do a detailed background check on you. But for the most part, it's not going to go on your record, right? And you just have to pay up to $100, and you can be on your way. I personally think that this is outdated. They need to bump this up to maybe $3,000 because you really want people to take jury duty serious. But once I continue on, you'll see that it's kind of null and void because you can easily get out of this. For the most part, you've already seen the question answered. What if the jury duty is going to cause a hardship? Well, you can just say, hey, I just have a hardship. So in this sense, only a stupid person would actually be fine because they could always just say, well, hey, I couldn't make it, I had a hardship, and just say, my mama's bad leg went out, and I had to pick her up and take her in the house, or something crazy, right? Something crazy and believable, and you can get out of it, right? Now, hey, look, I don't tell them that because I'm just making this stuff up, and I'm not a lawyer, and I don't know if you're gonna get off of jury duty by saying your mom's leg went out. So take it with a grain of salt. I am not a lawyer. And that is basically it. I'm surprised that's it because I thought there was more. But yeah, that's it. So that's it for this video. Basically, let me know what you think of this video. Leave your questions, comments below. Please like, share, and subscribe. And I'm really interested to see what you think about the provision where a person can be on the jury after forming an opinion or impression about the case. That is deep. That's some heavy, heavy, heavy stuff. Let me know what you think. Let me know what you think about that.